Has Your Honour had a chance to consider the pre-sentence report prepared by Mr. Taylor on this matter? I am grateful, Your Honour. Your Honour, in looking firstly at the facts of this case, as well as the personal circumstances of Mr. Harris, I seek to persuade Your Honour that although Mr. Harris's offence falls within the threshold of a custodial sentence, it very much falls in the lowest end of the applicable range. Your Honour, without wishing to detract at all from the seriousness of the offence, Mr. Harris does not wish to justify his actions, I stress, in any way. Looking both at the facts of the case as well as the applicable sentencing guideline, Mr. Harris's offence falls in the bracket of lesser culpability and Category 3 for harm, giving a range of high-level community order to 3 years of custody. And the starting point of this offence would be 1 year's custody. Your Honour, whilst this offence is clearly a specified offence for the purpose of determining a dangerous offender, it is submitted that Mr. Harris does not qualify as such on these facts. It is submitted that this is a one-off offence on exceptional circumstances. Your Honour, now I would invite you to consider the pre-sentence report in underlining this. At paragraph 4.1, Mr. Taylor has stated, I have not found evidence to support a conclusion that he is at present a dangerous offender within the meaning of Chapter 5 of the Criminal Justice Act 2003. Your Honour, in considering the aggravating factors of this case, firstly, it is conceded that one of these is the involvement of Mr. Harris together with 2 other individuals in the intimidation of Mr. Blake, the victim in this case. It is also acknowledged by Mr. Harris that he was unfortunately under the influence of alcohol and drugs at the time of this offence. And in Mr. Harris's own words, he states, he was out of it during the robbery. Against these factors, however, there are significant mitigating factors that should be taken into consideration, Your Honour. Key of which is Mr. Harris's genuine remorse for what he has done. He regrets not admitting his role sooner. In his own words, he has stated, I really am sorry for what I put Mr. Blake through, and I mean that whether or not I end up serving a sentence again. Your Honour, I do ask that you take this very genuine remorse into consideration when sentencing Mr. Harris. Mr. Harris also accepts the prosecution's account of what happened during the incident. He accepts his part in the robbery, and he also states that he must have handled the wallet at some point during the incident. However, although Mr. Harris was part of this robbery, it has to be acknowledged that he merely took on an ancillary role in committing this robbery, a minor role. He was simply following the lead of the other 2 individuals in committing this offence. Mr. Harris also, prior to the robbery, was begging in the streets for about 1 week. He was unemployed, he had no fixed abode, and he was simply not in a very good place. Your Honour, it is accepted that there are concerns with Mr. Harris's long antecedent history. However, those circumstances in which those offences were committed are very different from the circumstances as of now. With regard to the 2 most recent convictions, which are 3 dwelling house burglaries committed by Mr. Harris, he committed them against a background of growing substance misuse. And that has very much changed as of now, Your Honour. Your Honour, these mitigating factors clearly points Mr. Harris to a sentence at the lower end of the applicable bracket. Turning next, and briefly, Your Honour, at the personal circumstances of Mr. Harris. Mr. Harris, Your Honour, is now only at the age of 19 years old, and prior to his arrest, he was unemployed and had no fixed abode. Your Honour, Mr. Harris had also had an unfortunate, difficult childhood. He was subjected to the neglect of his parents, who were themselves dependent on alcohol, and he had also been bullied and expelled at the age of 14 years old, putting a stop to his education. His lack of employment and education has caused him to struggle to reintegrate back into society, and he at that time, before the arrest of this offence, quite a limited and hopeless outlook of life. Your Honour, Mr. Harris's difficulties with substance misuse is very much of the past. Since the time of the arrest of this offence, he has actively made changes to his lifestyle. He's currently bailed and curfewed to his mother's address, and this has been a very stable placement for him. He has formed a good relationship with his mother's boyfriend, Mr. Pierce, who has also had a stabilizing influence to Mr. Harris's lifestyle. In fact, he has influenced him to undertake some voluntary work with the Ground Force project, which he is now currently undertaking. This, Your Honour, has also motivated Mr. Harris to find employment in the future within a similar field as he is volunteering as of now. And above that, Mr. Harris has also shown motivation to get back into education by completing his GCSEs. In fact, Your Honour, I can confirm that Mr. Harris has had an offer and a place at Hanham College, and he will be starting in the beginning of the next academic year. Your Honour, Mr. Harris has now been free from both alcohol and drugs for more than 4 months, and according to him, he claims that this has been the longest period of sobriety, and this has also been endorsed by the agencies that he has been working with, and therefore it is credible, Your Honour. It is submitted that although it has to be acknowledged that Mr. Harris's long history with substance misuse poses a real risk that he may relapse, it is submitted that Mr. Harris can now identify new coping mechanisms to cope with this and avoid any such relapse in the future. Your Honour, whilst a custodial sentence is the starting point for this offence, putting Mr. Harris into prison would have a disastrous effect and would remove him from the position of stability which he has managed to achieve over the recent months. And in fact, it may also negatively impact on his motivation to avoid reoffending. Furthermore, I asked Your Honour to take into account that whilst Mr. Harris did initially plead not guilty, he later decided to acknowledge his guilt and did so before necessitating a full trial. As such, I invite the court to give credit to this guilty plea at an amount that the court deems appropriate. It is in my respectful submission that a 10% reduction would be suitable. Your Honour, in light of the mitigation that I have put forward, as well as the impact of prison on Mr. Harris's life, I would ask Your Honour to follow the recommendation on the pre-sentence report, namely a recommendation for a 2-year community order with a rehabilitation activity requirement for 24 hours and an unpaid work requirement of 200 hours. This, Your Honour, would not only provide a proportionate and an appropriate punishment for Mr. Harris, it would also allow him to integrate back into society, giving a positive change to his lifestyle. Your Honour, that concludes the end of my submissions, unless I could be of any further assistance.